All right, so hopefully you can I've just opened up the front of the Moodle front page for the sake of the discussion. The first thing I wanted to talk about is that I've been going through the process in the last couple of days and in fact, they're all in front of me right here. I'll grab them for the discussion. There's some, and here's the rest. Of printing out all of the assignments, and then I mark them in paper form, and that is red pen them. The other thing that I have on the screen in front of me is an Excel spreadsheet with all of the student numbers, student names, the mark for the first question, the part marks for this, the parts of the second question, total for the second question, total for the assignment, total percentage. And of course, that allows me not only to mark each individual paper, but to constantly moderate my marking so that as I'm doing an individual paper, I'm checking to make sure that I'm cross-referencing the whole time with all of the marks and looking at all of the marks as they're being entered as well. What I'll then do once I feel as though I've got all of the marks and I've sort of self-moderated myself, I'll then get to the point where I start scanning the paper versions of the assignments as marked, and then I will upload those into Moodle for you, putting the mark in and then sending those out in the internal system through Moodle. So you'll see obviously the assignment marked, the mark, etc. You will have seen, so that's the first assignment, and I'm very conscious of all of the work that went in on that and your efforts, which I've already been reading and of course going through. In terms of the exam, you will see on the news forum, hopefully you've already seen that I've done a little initial articulation of the examination. And if you've had the chance to watch that, you'll see that I've talked about both the standard exam and the supplementary deferred exam, primarily to give you a window into my thought process, to give you an idea about the methodology of the exams, but also so that you can see that the methodology of the exams, that is the standard exam and the deferred exam, are basically the same. The style of questions are the same, but they are different questions, if that makes sense. The style, the method of the exams are the same, but the style of the exact wording of the questions is slightly different. And they just have some slight differences there, of course, to make sure it's completely and utterly fair. You'll also see that I did a Zoom recording, just a short recording, on some of the thoughts about the second assignment, particularly on the model, if we call it that, the statutory interpretation model there on the second assignment. The big thing that I want you to take out of the second assignment, but also generally, is that one of the things that I took out of a lot of the communications that I received about the first assignment, and I got, you can imagine, with over 100 students, I think, at last count or from recollection, in this subject, you can imagine I got a lot of communications, and I was very pleased about that. And all of those that did communicate with me will know that I responded as soon as I possibly can to any of your communications. The big thing, though, that I took out of that is when people are worried, a lot of people said, I'm really worried about something. When they communicated with me, I hope and I think, judging from those communications, I think the vast majority of people, a lot of their concerns were alleviated, or their primary concern was at least diminished. And I think that would be something I really want to reinforce with you, is that you should feel as though you're thinking, oh, I'm worried about something, or I'm concerned about something, you should feel as though you can communicate with me. I think if you don't communicate with me, it gets worse, and of course people start to get worried about things, and that's the opposite of what we want to have happen here. We want everybody to be positive about this learning experience. So as I've mentioned on the front page, and I was very sincere about, you should always feel as though you can communicate with me at any point in time. The other thing that I took out of the first assignment, in terms of a lot of the communications that I received, people had very, very high expectations about what they were required to do. The big thing, at least from my point of view, and I can only speak obviously from my point of view, I'm very conscious of us as a group and where we're at. That is, we're at an initial page, in the initial stage, I should say, in the Bachelor of Laws degree, a formative stage. I don't have radically high or unrealistic expectations about the fact that we're just going through an initial learning process together. And so I'm very conscious of that, and you shouldn't be worried about this subject. For example, worried about failing. I think those that engage, hand in their assessment, and engage in the subject will find that you will do well. I'm very confident that you will do very well. Okay, so let's have a look then. We're having a look now at this idea of intention and interpretive techniques. All right, so the first thing I wanted to say to you about this week, and you will have picked this up from the things that I've been saying in the past. Can you see, by the way, the notes? Are they popped up for you?
Yeah, we can see them, Dominic.
Great. The first thing I wanted to say about this week is, as I think I said to you when we last were together, this is very much an academic process. What I mean by that is, we're looking at things in a very academic way. Judicial officers are not going to use terms like ambulatory interpretation. You're not going to hear a judicial officer, that is a judge or a magistrate or a tribunal member, use those types of phrases. We're thinking about statutory interpretation from an academic perspective, not from a practice perspective. So in that sense, the difference, I think, is a significant one, because when you think of it from an academic perspective, you're becoming theoretical, you're analysing, you're trying to describe what a judge does, even though a judge doesn't describe it that way themselves. You're looking at, and I used this description when we last spoke, you're looking at the way a judge does things, and you're looking at it academically from different perspectives and giving that mechanism that the judge uses lots of different names. And in that I think's one of the difficult things about this subject, because it's theoretical and because it's not practical in the way that it approaches the learning, not practical in the sense that academics are trying to generate theories about how judges do things, but they're not actually talking about the simplistic approach that the judge often will use. I think that's what makes this subject challenging, because it's quite academic. But what I want to reassure you about is this, and you'll know this if you've had the chance already to watch the examination recording, and that's this, that the exam is not so theoretical in the way that it approaches the process of statutory interpretation. That is, the exam has a set of facts, it has a section, and it allows you then to interpret it. It's not asking you for a very radically theoretical interpretation of the process of statutory interpretation. It gives you an opportunity, though, to, of course, pick up some of the things we've learnt throughout the semester, but it's not creating some ridiculous theoretical examination for you to work with. So I mention that because from my point of view, when I read through our notes for this week, I kept thinking to myself, this is so theoretical. All these things that are talked about in these notes, these aren't practical, practice-like things. These are theoretical, academic-like things. So let's have a look at these key terms to start with. So ambulatory interpretation, it's this idea that there's a dynamic interpretation. It can change over time. The best example of that, I think, is the Constitution. Think about the definition, for example, of external affairs in the Constitution. When those who drafted the Commonwealth Constitution originally, and of course it hasn't changed in terms of the section we're talking about when we talk about external affairs, when they drafted it, they were thinking about the Commonwealth's relationship with other countries, other states, other sovereign powers. They would not have thought that in the 1980s, when the Tasmanian government decided they'd build a dam in Tasmania, that the Commonwealth Parliament would use the external affairs power to go overseas and sign up to a treaty and then use that as a basis to go to the High Court and stop the Tasmanian government from building a dam in Tasmania, the Tasmanian Dam's case. I think that's an excellent example of an ambulatory interpretation. That is, the interpretation of the Australian Constitution, the Commonwealth Constitution, changed over time. It was a dynamic interpretation. It allowed for a different meaning than the meaning that had originally probably been envisaged by the founding drafters of the Constitution. Equity is something you may have come across in introductory law or in your other study. Equity law, remember, is the law that developed, or the system that developed in England over hundreds of years, parallel to the system of law. So remember the idea that something like contract law was rigid and had specific rules, and those rules were dealt with, say, in a local village in England often by the religious person or by a judge or magistrate, whereas equity was the law made by chancellors representing the Crown. And so law and equity existed as parallel systems until the Judicature Act merged them together in the 1870s. So you had equity law, or you had equity, and you had law. And when they were merged, we suddenly had one Supreme Court, one Superior Court, with a judge, but a judge who was both a judge at law and a chancellor in equity. And that's why today, of course, on a normal day in court, a judge wears black robes, signifying the relationship with the law, and on special days, the judges wear red robes, signifying their relationship with equity and the chancellors who wore red. So when we talk about equitable interpretation, we're picking up that idea of equity, this idea that fairness equity law can impact upon how we will interpret legislation. That law shouldn't just be rigid, but it might also have some equitable fairness way of interpreting it, which picks up the universal and the spirit and the reason behind why the law was put in place. The next word, intention, when I think of intention, I think of something in criminal law. And criminal law is not an area that I know much about. But what I'm saying there is that when I think of intention, I'm thinking of the idea that in certain offences in criminal law, there's this concept of an intention. And it's something that I think about when I think about an individual person. Now, what's interesting about intention in statutory interpretation is we're talking about intention with regards to what Parliament meant to achieve. And of course, that's a difficult concept because there's no one human being that is speaking for the Parliament. They are just all members of the Parliament. Of course, a minister might be the person who puts the bill to the House and reads the second reading as to the bill and tables the legislation. But it's very difficult sometimes to identify the intention of Parliament as a whole. Now, reading down and reading in, I think are the easiest of these concepts to understand, or they're easier to understand in the sense that you read something down. So if it's a grey area, you go back to, I remember in the first week we were talking about reading it down. We were talking about reading down tax legislation. We were saying if there's a grey area and the question for the judge involves a question between favouring the tax office or favouring the taxpayer, well, traditionally they read down the legislation and would always favour the taxpayer. They'd read down the legislation, read it narrowly, give it a limited meaning. Reading in is the idea that there might be almost adding words in. It's almost like there are words missing somewhere in that section. Adding extra words to try to give effect to what Parliament's real purpose or their intention was. To pick up what might have been said in the second reading speech, or to pick up what might have been said in the explanatory memorandum about an act. Okay, so Australian construction, is the last one. That's reading in additional words to give effect to the purpose. Now, you'd never hear a judge talk about Australian construction. What they would talk about, though, is they might refer to the requirement to add some words to give effect to the purpose of the legislation, to, either through an error in the drafting or through the drafting not picking up some factual possibility. There was a requirement to work out what the section means, having regard to that possibility, that factual possibility. And so what I was talking to you right at the start before, when I said that this is a very theoretical analysis about something which judges do quite practically, I think that introduction reflects that in what it says there. It says this chapter's about statutory interpretation. It's about how judges and courts and tribunals, etc., find the correct interpretation, but it looks at that process in a very theoretical way. Even that word find the correct interpretation, you won't see a judge talking about how they find it. They'll just give their decision. They'll just give their reasons for the decision. So let's have a look at this first one again of intention. It's interesting because they give a dictionary definition of intention. And as I was saying to you before, when I think of intention, I think of the Criminal Code of Queensland in the way that it defines intention in a criminal context. And the challenge here is, of course, you're trying to find the intention of Parliament. And as I said before, Parliament isn't a unified, singular body. It has people within or members within the Parliament that will speak about certain topics. There'll be debate in the Parliament. There'll be a minister who might have a primary role with regards to legislation. The government will be controlled by the party or parties who are in government, but none of those things is purely unified. So even the theoretical concept of being able to find the intention, it's very much a theory, because the reality is not that simple. You can articulate, or you can look at a piece of legislation in terms of what its object is, which is what they do here, but you can't get a clear articulation of the parliamentary position. If you asked me, what is the legislative position, or what's the position of the legislation, very different. Then you can get a clear intention. So they talk here about restricting cigarette advertising. And you've seen all of those different things that have occurred in that regard. You know, in a service station now, they have the covers over the cigarettes behind the counter. When you buy cigars now, they have plain packaging, even on a cigar, things like that. So the purpose or object of the legislation is obviously to improve public health. As stated, this Act is intended to limit the exposure of the public to messages and images that may persuade them. But you can see straight away that there is going to be a disconnect, isn't there, between that object of improving public health and how the statute might play out in a very detailed sense in what it's allowing and not allowing tobacco companies, etc., to do. And so when we're talking about what you can do with a cigarette packet or what you can't do, or when we're talking about what you can do with a cigar tube or a cigar box, etc., you can see how there will immediately be a disconnect between the object of the Act and the specific sections that might be included in it. And you can see there's a further disconnect between the intention of Parliament, the object of the legislation, and the specific section or sections within the legislation. So you're trying to identify a purpose, and then you're trying to apply it to the specific interpretation of a specific provision or provisions. So straight away, and I hope you can see from that there's immediately going to be a disconnect between this theoretical idea of how we achieve it and the practical, the challenge that confronts the judicial officer each time this process occurs. The next case they mentioned is a High Court of Australia decision from 2011. You will know already that when you see 2011 in square brackets HCA 32, that's the internet reference that you'll see, for example, on Ostley. Once the case is reported, that is the formal process where it's published in a formal way, usually it'll have the Australian Law Report or the Commonwealth Law Report, the different formal authorised reports for the High Court of Australia. Plaintiff M70 of 2011, it was a case about the Migration Act. Now, because obviously it's been a topic that's been very much in the media for many, many years, right back to particularly from 2001 onwards, when you might remember the Tampa incident occurred towards the end of 2001. That Migration Act has been amended very many times in that period by all sides of politics. And so there's a lot of new provisions in that Act, and therefore, of course, a lot of interpretation needs to occur about the Act. And not only has the Act itself been amended lots of times, of course, all of the factual circumstances about things that are occurring change. Where people are, whether they're out on the ocean, whether they're on Christmas Island, whether they're in Australian water, economic zone, territorial zone, etc. All of those sorts of factual pieces of information change. And so the court is confronted with all of these interpretation questions about what is relatively new and changing legislation, and then about matters that are really quite political and involve a lot of policy questions. So the purpose or the intention of Parliament then becomes obviously important, because it's underlying the changes that were made to the legislation. And you can see here in this case, as it says there, the High Court read down the provision in the light of the legislative intention, which they thought, which the High Court thought, was to facilitate Australia's compliance with its obligations under various refugee conventions. This was a challenge to the offshore processing mechanisms that were in place. And obviously, even since that case, there's been changes again to the Migration Act, and there's been a whole heap of things that have gone on. But what you can take out of that case is that the High Court read down the provisions. They read down the provisions because they were looking for the intention of the changes to the legislation. They were looking for the purpose of the changes, the purpose as articulated by the legislature. And Gleeson, as he then was, the then Chief Justice, spoke in that case about the importance of searching for this intention. And, I mean, what he was really saying was, what was the purpose? Why were these changes made? What were they trying to do? And the answer was, they were trying to act in accordance with the refugee conventions that had been signed up to at the time. And the big thing, though, that he said, that is the then Chief Justice said, is he said, we need to find this out, because as the judiciary, we're not making laws. We're applying the laws that they've made, and we need to try and apply them in accordance with their purpose for making them. And why do we have to do that? Well, because they've told us in the Acts Interpretation Act, that's what our job is as interpreters of the legislation. Enforce the will of Parliament, as it says there in the last sentence. So you can see what I mean when I say it feels like we're looking at the same piece of information from a different angle. So we've just looked at intention, now we're looking at will. So what is this will of Parliament? I think the first sentence I'd say to you when I read that, I thought, when textbook writers and the courts themselves talk about the will of Parliament, well, it's predominantly it's the textbook writers talking about the will of Parliament. Courts will talk about, you'll find courts talking about the purpose, the objects, the second reading speech, the explanatory memorandum. Are they speaking about a group of politicians? Well, of course not. And that's because of what we were saying before. You can't get a unified perfect view or perfect intention or perfect will from the group of politicians who are those in the Queensland Legislative Assembly or the House of Representatives or the Senate in Canberra. The intention as it's described there, is this idea that you're examining the statute in terms of its purpose and also its context. So you're going back and you're looking for that extrinsic material that will assist you. Remember, we've spoken about that in the last couple of weeks, that idea of extrinsic material. The courts don't look at what Parliament wanted to say, they look at what Parliament said. They don't look at what Parliament thought they could say or might have said. What was their purpose as actually articulated? Intention isn't about misunderstanding the thing, it's about understanding it. It's about working out clearly what were they trying to achieve. I think this third bullet point is an important one. That is, you're looking at it objectively. Objective as opposed to subjective. Objective is, what would a reasonable person looking at this information say was the articulation of it, or say the purpose was? Not what did that individual parliamentarian think, or what do I think, or what do you think, but what would the reasonable person as a generic set think? And it's very difficult because none of us really is the reasonable person. So we're trying to blend us all together and to work out what that means in a reasonable sense. Judges have spent a lot of time talking about what a reasonable person would think, i.e. what an objective person would think. You know, they used to talk about the man on the Clapham Omnibus. You might have heard that phrase before, which was the idea that in the 1950s in England, the objective person or the reasonable person was that person who sat on the bus and didn't talk and read their newspaper in the morning, and they wore a suit and they were just going about their business. They got onto the bus quietly, they sat down, they had a hat on, they read the newspaper, and at the end of their stop they got off the bus. And one of the judges used this to describe, well, this was a person without a name, and this was a person who just went about their business in a reasonable way, going about their daily activity. And what they were trying to say was that we needed to try to get into the mind of that reasonable person to work out the objective intention in the circumstances. And in our case, the objective intention of Parliament. And that really relates to what's being said down the bottom here. How do you look at the document itself, and what does the document say to a third party? And when we're talking about a third party, we're talking about that objective person out there. What would that person think? Not what Dominic would think or what you would think, because the minute you create that subjective perspective on something, you're losing the reasonableness of it. And even as I'm saying this, I'm thinking, this is so theoretical. That's not what the judges don't sit there talking about all of these things in their judgments. They say, what does this section say? What did the second reading speech say? What did the explanatory memoranda say? What did the what does the regulation say? What do the other sections say? What does a dictionary say about some of these words? What did Justice Bloggs say when these words were used in another act? Okay, here's my decision on the facts. They don't get into this theoretical type analysis of it. Okay, so what do we do if there's no parliamentary intention? So if we've got no extrinsic materials from the legislature that give us the purpose, we don't have an objects clause, or maybe we don't have a second reading speech. So how do we deal with that? And obviously here they mention Mills and Meeking. which is a 1990 High Court decision. Justice Dawson, who was a Victorian justice, long retired now, but he said, as Lord Diplock, now, so he's talking about one of the House of Lords judges, Lord Diplock, in Jones and Rotham Park Estates, the task on which a court of justice is engaged remains one of construction. Even where this involves reading into the Act words which are not expressly included in it. His Lordship said that words could only be read into a statute if three conditions were fulfilled. The first is that the court must know from a consideration of the legislation read as a whole precisely what the mischief was, that it was the purpose of the legislation to remedy. Secondly, the court must be satisfied that by inadvertence, Parliament has overlooked an eventuality, which must be dealt with if the purpose of the legislation is to be achieved. And thirdly, the court must be able to state with certainty what words Parliament must have used to overcome the omission if its attention had been drawn to the defect. Now, the first thing is, both Jones and Rotham Park Estates has been overridden by statutory obligations placed upon judges now within our Australian jurisdictions. That is, a judge isn't supposed to read words into a statute as the way of interpreting the statute. A judge is supposed to apply the purpose to determine the meaning of the words that are there. So this is a test developed by an English judge as to how, in those circumstances, and that predates, I think, anything like the purpose rule in the English context as well. But that's an example of how judges dealt with some of these problems in the past. And you will know that the mischief rule has been overtaken by the purpose rule. The mischief rule was an older common law method of statutory interpretation, and we will look at that in due course. And obviously paragraph 21, Lord Diplock goes on to talk about the specific sections in that he was dealing with in those circumstances. But if there's no parliamentary intent, then the real approach that should be taken is a literal approach. That is, what do these words mean when I read them as if a reasonable person, an objective person, was reading them? I don't have any purpose to go back on. So if I don't have any purpose, I'll take the statute on its face. Diplock, well, that's an old way of trying to achieve a purpose-like approach, or a parliament where there's no parliamentary intention. He was trying to achieve an outcome in that specific set of circumstances. The other comment I'd make at this point in time is that an academic point of view on things will say to you, or the academics will say to you, judges they'll try to find similarities between the way judges do things. And the reality is, judges look at the problem before them and they deal with that problem. If they need to solve this problem, they might go and look at some other case that's been relevantly solved on a relevant set of words or a relevant set of legal issues. They're not looking at it the way an academic will look at it, which is to say, the academics will say to you, judges will always use mechanisms or processes or procedures, or they'll always look for parliamentary intention or no parliamentary intention, or the will of Parliament or no will of Parliament. No, they'll apply the statutory obligations upon them, and then they will seek to take legal information out of other cases or out of those extrinsic materials to the extent that it helps them to solve the problem confronting them at the time. Okay, so let's talk about the interpretive techniques a little bit more, reading down being the first one. Reading down, as I mentioned before, whenever I think of reading down, I think of that taxation context. That where there's any grey area in the words in question, I'm going to narrow the result to favour the taxpayer. Or maybe it's the example of think about when you drive into a car park, very expensive car parks in Brisbane, and you go into a car park and it has a sign, for example, that says, cars shall be parked at the owner's risk. Now, let's say you take your bicycle, just your push bicycle, not motorbike, into the car park, and it's stolen or it's damaged by a car park attendant. Does that exclusion clause, cars shall be parked at the owner's risk, does that cover, and let's say, and you'd paid to put your bicycle in that car park, does that exclusion clause potentially cover the car park company from liability where one of their attendants damaged your bicycle where you'd paid consideration to store your bicycle there at the car park? Now, we're talking about a term in a contract and interpreting the term in a contract rather than interpreting a term in a statute. But think about it. If you're the judge, are you going to say, well, when they and you're interpreting those words, when they used the phrase, cars shall be parked at their own risk, what they meant to say was, i.e., are you going to read in to that phrase, cars and motorbikes and bicycles shall be parked at your own risk, i.e., you're going to read in those words? Or are you going to read down those words and say, well, by cars, they meant motor vehicles, however so powered, that might include an electric vehicle, it might include a utility vehicle, a panel van, it might include a four-door car, a two-door car, an SUV, etc., etc. But it doesn't include a bicycle or a motorbike. You can see that the reading down is far easier to do than to read in. To read in means that a judge or a decision maker is interpreting a statute, adding meaning into it because they think that meaning fits with the purpose of the statute. Now, leaving aside whether that is the appropriate thing for the judiciary to do when they've been told to do something by the legislature, it's still important we understand what the two are. So reading down, I always find easier to understand, and in the sense that it's where there's a grey area, you'll read it in a narrow way. Think of that example I gave you at the start about tax office and taxpayer. It's a bit uncertain what this means, so I'm going to favour the narrow reading of it. Reading in, the court will want to strain or extend a meaning by reading in additional words in order to give effect to the purpose. Not easy for a court to argue that it's appropriate to strain the construction and to effectively add words in. I mean, sometimes it could be let's go back. I think one example might be the tobacco company is arguing that they are able to, that the statute doesn't cover some type of tobacco advertising that they're trying to do in the new legislation. And the court is having to interpret the new legislation. Well, it's absolutely clear from the purpose of the Parliament, as articulated by the Minister and as articulated in the explanatory memorandum and in the second reading speech and in the objects clause of the Act, that the Parliament wanted to ban all cigarette advertising, wanted to ban all advertising of whatever means to do with cigarettes. So that's, I think, an example where where a judge could potentially read in additional words in order to give effect to the purpose. What they're really saying in those circumstances is that the statute, there's actually a drafting error in the statute. It had the draftsperson had the opportunity to think through this scenario, they would have included these additional words. It's not that Parliament didn't want the words in there, it's that the person who actually sat down to draft that provision or those provisions, etc., didn't include those words, but Parliament wanted them to include those words. And it was purely an exercise of the failure of the functionary who had the task of putting the words into the statutory form, the draftsperson doing that. And of course, the next step is Parliament would potentially, as they're saying down the bottom of this page, amend the legislation to pick up that concept, or to make that change. And often one of the things that often occurs is that in between, while a case is actually running, Parliament will amend the legislation so that by the time the judge gives the decision about the legislation as it then was, the legislation's already been changed. And often that's brought to the attention of the court to say to the court, well, this is indicative of the intention or the purpose of the Parliament under the old legislation as it then existed. Dynamic interpretation, well, this ambulatory, and this is, you recall at the start we were talking about the Constitution. I'll give you another example from the Commonwealth Constitution. We were talking about the external affairs power at the start of tonight, but another head of power that was used in a very different way that is a different way from the way that it was envisaged potentially at the time of Federation in 1901, was the corporation's power. You might remember that in the mid-2000s, I was going to say the mid-1990s, in 2005, the Howard government amended the Workplace Relations Act 1996 to put in place amendments regarding industrial relations, which were called the Work Choices Amendments. Work Choices, you might remember that name, Work Choices. The Work Choices changes were done under the Commonwealth Corporations power. So you had a head of power given to the Commonwealth in the Commonwealth Constitution that said, you're able to make laws with regards to companies. But here, they were using the laws with regards to companies to regulate the law as to the employer-employee relationship. So I think this is a really good example of a dynamic interpretation. So the matter, it went to the High Court, and 6 of the 7 judges said that you can use the corporation's power to regulate the employment relationship, and that so the legislation was valid. One judge said, no, you can't do that. And of course, the court relied very much on the Tasmanian Dams decision in 1983, which I mentioned earlier tonight. That is, they said, you can apply a dynamic interpretation to the meaning of these heads of power in Section 51 of the Commonwealth Constitution. And all that you've got here in your notes is they give you they give you a New South Wales example in the Deputy Commissioner of Taxation and Clerk. They just give you another example of how legislation can be dynamically interpreted. But I think those Section 51 examples from the Commonwealth Constitution are very good examples and very interesting examples of where the High Court took a very dynamic interpretation to the different heads of power in the Commonwealth Constitution, which obviously has, very significant impacts upon our whole, life, really, in a lot of ways. Equitable interpretation is the next one. Now, remember what we were talking about earlier in terms of equity and the law, and equity is all about fairness. Whenever I think of equity, I think of the story we were told when I did Introduction to Law, which was about 2 fellows in a village in England 500 years ago. And one fellow goes over to his neighbour's house and he says, I'd like to buy some sheep from you. And he says, how much will the sheep cost? And they agree on a price of £1 per sheep, or, something like this, £1 per sheep. And he says, okay, when will I collect the sheep? And he says to him, I'll come back tomorrow and collect the sheep. And he goes over to the house the next day. He hands him the £30. He says, where are the sheep? He says, they're round the back of the shed. He goes around to the back of the shed and there are 30 dead sheep around the back of the shed. Now, in contract law, was there an offer, an acceptance, an intention, and a consideration, the tests of a contract? And the answer really is yes. Did they ever discuss whether the sheep would be living or dead? No. Therefore, the contract would stand. The law would say that contract stands. But is that fair? What would equity say? And 500 years ago in England, the fellow who was aggrieved because he'd bought the dead sheep and he wanted a living sheep, he might have written off to the king or the queen. The king or the queen might have sent out their chancellor to communicate with him. And the chancellor would have said, well, I know what the laws said, but that's not fair. Fairness would say, return the dead sheep, return the £30 or whatever it was, and you can go and sell your dead sheep to someone else and you can go and buy living sheep from someone else. That's equity, that's fairness. So think about that now in terms of equitable interpretation. So we're thinking about an interpretation that looks at what's fair and looks at the true substance or spirit of the law, looks at the fairness of what's going on. Surely Parliament, and this is the theoretical approach to it, surely Parliament weren't trying to create a situation that was fundamentally unfair or that had some unintended consequence. One of the questions on your exam involves an unintended consequence by virtue of legislation. And so think about that in terms of how that might impact upon the statutory interpretation of a provision where there are unforeseen consequences in applying the provision on a certain reading of it. And maybe we need to interpret it in a different way to achieve that fairness. And we're still acting in accordance with the purpose of the legislation. That's actually, I was looking at that picture earlier today thinking that I'm pretty sure that's a picture of the moot court at the University of Queensland, or at least it was the moot court before they did the renovations to the law library at the University of Queensland. I don't know why the guys are wearing wigs, but for whatever reason, it must have been something was going on. So we've got a range of different theoretical ways of interpreting legislation that we've spoken about tonight. The big thing, though, is a number of them are very, what I'd say, out there. That is, reading in is out there type stuff. Reading additional words into legislation. It's the sort of thing that as a judge you'd be hesitant to do. To add words in, to go beyond just the purpose and the purpose as stated and the words in the statute itself. Of course, you might use an equitable interpretation to avoid ridiculous outcomes. You know, I remember doing a case many years ago, and I thought of it today as I was reading these notes. Many years ago, I'm thinking it's about 2002, something like that. And what it was that there was a fellow who owned a house in the western suburbs in Brisbane, and he was doing some renovations, and they dumped a lot of soil, from recollection, at the front of his house, and his house had quite a steep driveway. And when they dumped the soil there, I think it was tarpaulin or something, but they were using the soil over time. And of course, there was a heavy rain shower, a bit like we've had today, and a heap of this soil went running down the driveway and running down the front of his block onto the road. A city council employee or someone came past his house, and they used a provision which was in I think it was like the Water Plan 2000. I forget this now, what it was called, but there was a Water Act, and there were a number of pieces of legislation that related to the Water Act. There was one called the Water Plan, and there was this very, very obscure provision hidden in this Water Plan that said, basically that said you should not dump soil on a road. Now, this fellow, he got a very serious fine, and there was all this sort of problem. When I say a serious fine, it was like a significant fine, like $15,000 or something at the time. So it was a statutory breach under these provisions. And I just remember I was briefed, and it ended up going to the district court on a district court appeal from a magistrate's court decision. And the Brisbane City Council were on the other side. This fellow won in the magistrate's court, and he won in the district court, and we got costs. And basically, the nub of it was that it required a dynamic interpretation. These provisions had been put in place to stop people doing ridiculous things like dumping a truckload of soil on a road somewhere and just leaving it there. This was just natural erosion. But we went through a very intricate process of interpreting the different provisions in question. And so we were looking at the meaning of all these words, like what does dump mean, or what does as opposed to leave, as opposed to, erosion. What do all these different things mean? I can't remember the detail of it now, but I thought of it today when I was reading this in the context that the interpretation that the judge was required to apply, we went looking, of course, for the purpose. We couldn't find the purpose. So we were having to interpret the individual words and then relate those to the individual facts. And the significant thing there was that the legislation was having unintended consequences and was being used in a way, or at least that I argued, in which the court agreed, or I submitted and the court agreed, being used in a way that it wasn't intended to be used for. All right, so let's go through these different questions. Now, you guys can help me with some of these because I've been doing far too much talking. Josh, can you read out the first one for me, please? Don't worry, I'll get lots of people to do it.
Yep. So Chief Justice Gleeson has said the intention is discovered in what way? A, by referring to the Parliament. B, by considering what individual parliaments meant. C, in the meaning of the instrument using established principles of the construction. And D, by reference to previous laws.
Thank you. Catherine, what do you think?
You can hear me. I'm having a few problems.
Say that again?
I can hear you, Catherine.
Yeah, I'm going to say hopefully you can hear me. I've been having a few problems with my mic.
No worry. You could have just said. Somebody the other day just went, I can't speak. Yep.
That's a better idea. I should have tried that one.
Yeah. Everybody will try that now. Everybody will try that.
Goldfish.
So what do you think? Chief Justice Gleeson has said that intention is discovered in what way?
I would think a few of them actually probably apply.
Yeah.
In different ways.
I'm reading in to this multiple choice question when I read it, and what I mean by that is when I was working at the court, Chief Justice Gleeson was the Chief Justice. So I think about him, and I can tell you what that means. So he was the sort of personality type that I think it's fair to say that if you went and got one of the books on his shelf, and the books were lined up on the shelf, and you took one of the books out, his personality type is that he would be sitting at his desk, he would stand up, walk over and push that book back in. He was a detailed personality. His desk was always perfectly empty. He would only be working on one thing. He would finish working on it. He would close it. That was the personality type. So think about how that would play out in the way that he would deal with interpretation. He would be looking for something very structured. He would be looking for a way of interpreting the legislation in an established way. So that's why C to me would be right. He's not worried about what an individual parliamentarian thinks or means, because that's going to take too much time and it's not going to be certain enough for him. He's not going to worry about the intention of Parliament, because there is no such intention. He's not worried about previous laws because they've been repealed or they're not this law. So it's C. And the other reason I like C is because I remember watching a documentary on multiple choice questions and the United States Marine Corps, and they were teaching the Marines that even if you don't know the answer, always pick the longest one, because statistically it's right.
I like that idea.
Question. Erin, Could you read out question 2 for us, please?
The view of interpretation of legislation which suggests that there is a spirit and reason behind the law is what? A, dynamic interpretation, equitable interpretation, fair interpretation, or flexible interpretation? And I think it's answer A.
A, dynamic. So dynamic, the 2 examples I gave of dynamic were the constitutional heads of power and the external affairs power, so there's a spirit and reason behind the law. So when I hear spirit and reason, I actually think purpose, but really what they're getting at here, I think, is this idea that the spirit and reason, well, when they passed that thing, go back to my case example before about the fellow at the house in the western suburbs, and he's, the dirt's run down the hill. Well, Parliament really trying to punish this bloke because in a rainstorm some dirt ran down the front of his hill in a big storm, and some of it went on the road. It wasn't stopping the car from going past. It wasn't stopping a car from driving. It wasn't hurting anyone. It was just going to wash away in the rain. Yeah, it wasn't good having some dirt on the road, but it wasn't exactly the end of the world, and maybe a fine, but maybe not a $10,000 or $15,000 fine. And so to me, there was a level of equity about that, and I think so. Equitable interpretation. Melissa, do you want to read out the next one for us, please?
Yep. Sorry. What is the presumption that we can make regarding each separate provision in legislation? A, Parliament intended each provision to somehow give effect to the purpose of the Act. B, Parliament does not draft provisions in isolation. C, some separate provisions are less important to purpose than others. And D, not all provisions relate to purpose. And I chose A.
Why?
Now, think again.
Well, let me ask a different question. What do you think's wrong with B? When Parliament passes this Act and these provisions in this Act, are they wanting us to go and look at another Act at the same time, normally?
No.
Talking about Acts as opposed to regulations, because regulations obviously hang off Acts. But in Acts, are they wanting us to look at another Act?
No.
No, exactly. And if they do, normally they'll tell us. Having regard to, they'll put in the section, have regard to, the Subcontractors Charges Act or something, or they'll mention the other one. What about C? Why is C wrong?
Because all of the provisions are meant to have equal importance.
Good. And D?
Well, all provisions should also relate to the purpose.
Yeah, exactly. All right, everybody happy with that? I keep having to move the little... Can you see that, the little screen on yours? When I move it, can you see me moving it?
Yeah, it's good, Dominic.
Okay. Okay, next one. Peter.
Okay, so question 4. What does legislative intention refer to? The subjective intent of the Parliament which enacted the legislation, the overall intention and object of legislation, and objective intent to be ascertained using the text of the Act in the light of context and purpose, or the intent of the minister based on policy. And I think that it was C.
Yeah, so let's look at these other ones and why they're wrong. The subjective intent of the Parliament which enacted the legislation. So when I read that, I think that's got to be wrong, because how do we determine what the Parliament's thinking as a group, as a total group? Apart from anything else, in Parliament, you've got independent members, you've got members of different political parties, you've got members of the government, members who aren't in the government. So you're trying to generically identify the intention of a group which is in no way perfectly homogenous. So that's got to be wrong. B, the overall intention and object of the legislation. Well, legislation might have an object. I might be able to identify the purpose to it. I might be able to identify the context, but it just doesn't sound right when we talk about the overall intention. I don't know what they're meaning by the overall intention. And D, the intent of the minister based on policy. Well, the minister might express a purpose, particularly in a second reading speech, but the intent of the minister, that's a subjective intention. When I read it like that, I think it's a subjective intention. Based on policy, well, there's all sorts of things which might be policy. It might be party policy for that minister's party, for example, but that doesn't mean it's the legislative purpose. So C certainly sounds better than the others to me. The others, some of the parts of the others, like B sounds okay, but it doesn't sound anywhere near as good as C. Jason, can you do the next one for us, please?
Yep, sorry about that. The case of the Deputy Commissioner of Taxation versus Clark is authority for the proposition that the particular application of the provision in any act may vary over time. In what circumstance? I chose D.
Yep, so just read through all of them for us, please.
Yep. Parliament has chosen a formulation which is of intermediate scope.
Yep.
B, the intention of the original enactment is unclear. C, surrounding circumstances have definitely changed. Or D, Parliament chose a formulation of intermediate scope and a high level of generality. Excuse me, I can't get it out. Generality.
No, that's good. I haven't been able to pronounce normal words today, and I just think it's that time of year for all of us. So that case, you can see it was New South Wales Court of Appeal, NSWCA, and the Parliament chose a formulation of indeterminate scope and a high level of generality. So think about the tax context of things. So a good example of that in taxation law is income, for example, or ordinary income. Parliament doesn't define what ordinary income is in the tax legislation. And the reason they don't do that is if you draw a circle and you say, and I'm being metaphorical here, if Parliament in the tax legislation said, income is the following, A, B, C, D, E. Well, every Australian would say, that wasn't income, that was a gift. He just wanted to give me that money. I didn't earn it. It was a gift, so it doesn't come under that definition. So intentionally in the tax legislation, they have a number of formulations that are not determinative, that are not clear, and they're very general in their drafting. And they've done that intentionally because they're trying to capture all of the possible income. And to be honest, in fairness though, when they're talking about allowable deductions, they do the same thing. They have general deduction provisions. Any loss or outgoing incurred for the purpose of earning assessable income. Very broad, very general, very not determinative, but high level of generality. so that if it's a possible deduction, you can claim it. And if it's income, you have to include it in your assessable income as well. So D. Tawanda, could you read out the next one, please?
Question 6. What type of interpretation involves interpreting statutory provisions in the light of present context, including common law? A, dynamic interpretation. B, contextual interpretation. C, originalistic treatment. D, flexible interpretation. I'll go with A, dynamic interpretation.
Good. I mean, when I read this one, I thought about contextual interpretation. Originalist treatment, I don't really know what that is. I have no idea what that is. It's just made up. Flexible interpretation, well, it doesn't sound like an appropriate method of statutory interpretation. But contextual interpretation is obviously very important. The idea that you read a paragraph within a section in a certain way. You might read a subsection within a section in a certain way. You might read a section within a number of sections in a certain way. You might read a part or a division of an act within that act in a certain way, etc. So they're all contextual in the way that you're interpreting something. But where we look at what's going on in society at the time, i.e. what's going on in the common law at the time, and use it to assist us with the interpretation, that's a dynamic interpretation. A government has been elected. They are elected on a mandate of doing X, Y, and Z. They pass legislation. They say that the purpose of the legislation is to achieve X, Y, and Z. The legislation is challenged in the courts. It comes before the courts. The courts have previously applied a similar type of interpretation. They are looking at it in 2014 and they come to a specific result. That's a dynamic interpretation. I've run out of people, I think.
Do you want me
Josh?
to do another one for you, Tommy?
Yeah. You do another one for me? Thanks.
Okay, question 7. Okay, so which of these is the main drivers behind the preservation of the formalist approach to statutory interpretation? A, the doctrine of separation of powers. B, hierarchy of the courts. C, protection of the common law. Or D, maintenance of the rule of law. And if my grey matter is working, I think it's A.
Yeah. So when I read this, I looked at it and I thought formalist approach. So I think formal. I think of like a person wearing a black tie or something, and they're standing there, or a military person being very formal, and I'm thinking, how would that person in their dress uniform or something, how would they apply their responsibility as a judicial officer in interpretation? And I'm thinking, well, they'd be very formal, of course. What's the formality? Well, the formality is I have a job to do and I'm going to do it. What's my job? I'm a judicial officer. I'm not a legislator. I'm not going to make law. I'm not a member of the executive. I don't have power. I'm just a referee acting in accordance with a set of rules. And so when I think of that, I think of the doctrine of separation of powers. And of course, we don't have separation of powers system like the US system, but we have a system that requires judges to apply the law as passed by Parliament, who are supreme. And so, yes, they have to protect the common law, but the statutes override the common law. Yes, they have a system of hierarchy of courts, but statutes override anything the courts say. They'll pick up what other courts have done to interpret the law. And yes, they've got to maintain the rule of law, but the rule of law is maintained by keeping Parliament sovereign. Josh, you want to do another one, please?
Yeah, right. An ambulatory, always speaking and dynamic approach allows the meaning of words to change over time in order to give effect to the spirit of the law. It is also referred to as what? The flexible approach, the equity of statute, the equity of purpose, and the purpose of ambulatory approach. I'm going to go with A on that one.
An ambulatory, always speaking and dynamic approach, allowing the meaning of the words to change over time in order to give effect to the spirit of the law, is always referred to as what? Well, I don't have a clue what the purposive ambulatory approach is. I'm not sure about the equity of the purpose. We don't need to consider the fairness or otherwise of the purpose. That's policy. It's not for us interpreting the law to ask whether Parliament expressing the law or expressing the purpose, whether that's fair or not. I mean, of course we do that because we vote them in or not, but that's not a legal process or an interpretation process. The equity of the statute, so we're looking there at the fairness of the statute, the equity of the statute. An ambulatory, always dynamic, always speaking and dynamic approach allows the meaning of the words to change. Yeah, I agree with you, Josh. Flexible approach. The equity of the statute, when I read that, I'm thinking about, is the statute fair? That's this part of the question here. To give effect to the spirit of the law. I mean, you've got to be dynamic about how you do it. You've got to make sure that you don't create unforeseen consequences by your interpretation, or ridiculous consequences. But to be honest, if there is a ridiculous consequence and you think it's ridiculous by just interpreting the statute in accordance with its purpose, it's not for you to come to that conclusion. That's when you're becoming a lawmaker. So, good or bad, right or wrong, when legislation's introduced that says specific associations are unlawful, you need to apply that legislation, whether you think it's good or bad or right or wrong. So I had exactly that situation earlier this week. I was sitting as a tribunal member, and you've got a role to play when you're doing that, and your role is that you must apply the statutory framework that's been put in front of you. Whether I agreed or disagreed with that was irrelevant. What my job was to just apply those provisions. I know the answer is listed as B, but I do like A, Josh, which you mentioned.
Hey, Dominic.
Yep.
Just on that one, I definitely agree with what you said there. And I thought when I initially had the question that it was B or A as well, but actually I just spotted this reference in the textbook, and it just says an effort is made to give effect to the spirit of the law,
yes,
which has been referred to as the equity of the statute.
Yeah, and what page is that on, Peter?
That is on page 85. It's in the first paragraph under ambulatory or dynamic interpretation.
And that certainly fits with our notes, which when it talks about spirit, it talks about equity, which I think the notes have picked up that interface that's occurring there in the text. So just tell us that page again, 85.
Yeah, page 85. I'll read that section again if you want.
Thank you.
It just said, an effort is made to give effect to the spirit of the law, which has been referred to as the equity of statute. And it just says, although various expressions have been used by courts, they are all manifestations of a common approach, which is a triumph of substance over form and pragmatism over formalism.
Thank you very much. All right, last one. Tawanda, do you want to read out the last one, question 9, please?
What precondition will a court require before it may feel justified in giving a provision a strained construction? A, the proposed construction is neither unreasonable nor unnatural. B, the proposed construction is useful to make sense of the provision. C, the purpose of legislative provision is clear. I think I'll go with D.
Yep. So when I first read this question today, I thought, well, it's definitely C. And then I asked myself, which of A and B are correct? And obviously then the next thing I did was I went back and checked that paragraph from Lord Diplock, quoted by Justice Dawson in our High Court. And it's A. The proposed construction is neither unreasonable nor unnatural. So exactly as you're saying, Tawanda, D, which is both A and C.